The Supreme Court just stripped U.S. immigration agencies of their power, and that means your future could now rest in a judge's hands. This ruling doesn't just tweak the system, it rewrites it. This is Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. In today's video, we're breaking down the Supreme Court ruling that changed how immigration law is interpreted forever. What does it mean for your case? How could it slow down or speed up USCIS decisions? And who really holds power now? Stay tuned, because this decision affects everyone from family-based visa applicants to asylum seekers. What just happened? On June 28, 2024, the U.S. Supreme Court overturned what's known as the Chevron deference, a 40-year-old legal rule that had shaped nearly every major immigration policy since the 1980s. Under that rule, when a law passed by Congress was vague or unclear, courts would defer to how a federal agency like USCIS, DHS, or the Department of State interpreted it. It gave agencies tremendous freedom to decide how immigration laws were applied, from defining good moral character to determining who qualifies for extraordinary ability. But now, that power is gone. The court ruled that judges, not agencies, must interpret ambiguous laws. That's a seismic shift, because immigration law is full of vague phrases that used to be under agency control. Phrases like special immigrant, public charge, exceptional hardship, and credible fear are now open to independent judicial interpretation. In short, the final word moves from bureaucrats to judges. Why this matters to immigrants and applicants? Let's make it real. When USCIS made a decision, say, denying an H-1B petition or a green card, they could rely on their internal policy interpretation. Courts often backed them, even when the language was debatable. Now that protection is gone. Judges can, and will, second-guess USCIS interpretations. That means more immigration lawsuits, more inconsistent outcomes, and a longer road for agencies to issue final rules. For visa applicants, this could mean more opportunity to challenge unfair denials. But for USCIS and NVC, it could also mean more hesitation to approve borderline cases, since they know courts can strike down their reasoning. It's like the entire immigration system has lost its referee, and every decision might now end up in extra innings. A quick look back. The Chevron legacy. The Chevron ruling originally came from a 1984 case about environmental regulations, not immigration. But over time, it became the backbone of how the federal government interpreted thousands of laws. For immigration, Chevron allowed agencies to modernize rules quickly, without waiting for Congress. That's why programs like DACA, TPS redesignations, and various humanitarian parole programs could operate, often through agency interpretation, not new legislation. Critics argued that gave agencies too much unchecked power. Supporters said it allowed immigration to function in a gridlocked Congress. The Supreme Court's reversal now tilts the balance back toward the judiciary. And that's where things get complicated, because courts move slowly, and immigration law is already one of the most overloaded parts of the system. Who gains and who loses? Let's break it down. The winners, people whose cases depend on challenging USCIS interpretations. If you were denied a green card or a visa because the agency used a narrow or unfair reading of the law, you now have stronger grounds to appeal. Judges can reinterpret that statute without deferring to USCIS policy. The losers, those relying on fast-moving policy updates or humanitarian programs. Agencies may now take longer to act, fearing court challenges. Programs like parole for certain countries, temporary protection expansions, and asylum rule adjustments could face new legal obstacles. For green card holders, this could mean slower adjudications when USCIS revises guidance to align with new court standards. For visa applicants abroad, it could lead to inconsistent results, where the same case type gets approved in one district, denied in another. And for immigration lawyers, it means a flood of new litigation, challenging every gray area of immigration law. Real-life examples of the impact? Example 1. A family-based immigrant visa is denied because USCIS interprets a public charge factor harshly. Before, you had little recourse. The court would usually side with USCIS. Now, your attorney can challenge that interpretation directly, asking a judge to define what public charge actually means. Example 2. An asylum applicant's claim is rejected because the Board of Immigration Appeals defined particular social group narrowly. After the ruling, courts can reject that interpretation, potentially reopening cases that would have been lost. Example 3. Employment-based immigrants, especially those filing under EB1 or EB2, national interest waivers often face denial letters citing subjective terms like sustained a claim or national importance. Now, those terms can be tested in court without automatic deference to USCIS, so yes, this ruling can cut both ways, empowering applicants, but also creating legal chaos until consistency returns. What happens inside USCIS now? Behind the scenes, USCIS policy divisions are scrambling to rewrite guidance memos. Each new policy or adjudication manual entry will need stronger legal backing, not just agency interpretation. Expect processing slowdowns as adjudicators seek new training on how to justify decisions under the post-Chevron world. Agencies may begin relying more on congressional intent and case law, rather than their own internal memos. That could be good for long-term stability, but in the short term, it means confusion. If you filed or plan to file a case in 2025, expect longer wait times and possibly new evidence requests as the agency recalibrates the broader immigration landscape. The decision also has ripple effects across major programs. Asylum. Courts could now set their own definitions of what qualifies as persecution or credible fear, making outcomes vary regionally. DACA. Its legal foundation, built on agency interpretation, may face renewed court scrutiny. Humanitarian parole. Temporary entry programs for Afghans. Ukrainians and others could be more vulnerable to lawsuits challenging DHS authority. Visa modernization. Digital filing or AI-driven adjudication systems might slow as agencies worry about new legal interpretations. This doesn't mean those programs end, but it does mean the ground beneath them is shifting. What you should do now. If you have an ongoing or upcoming immigration case, here's how to prepare for the new reality. Understand your legal foundation. Ask your attorney whether your case depends on an agency interpretation or a clear statute. Be proactive. Submit well-documented, legally grounded applications that cite the statute directly, not just the policy manual. Expect uneven rulings. Until courts establish new precedents, similar cases may yield different outcomes across jurisdictions. Plan for delays. USCIS will likely issue more requests for evidence as it redefines how officers apply the law. Stay informed. This is not a one-time story. This change will ripple for years. For many, it's a chance to push back against unfair agency rules. But for others, it could bring new uncertainty until the courts stabilize the system. The bigger picture, separation of powers. Reborn, in one sense, the Supreme Court's move restores the traditional role of the judiciary, interpreting laws as written by Congress. In another sense, it opens a door to unpredictability, where federal judges, not immigration experts, set the boundaries. The message from the court is clear. Agencies no longer have the final say. The Constitution's separation of powers now takes center stage again, and immigration, being one of the most complex systems in the nation, will feel that change first. For immigrants, this is both empowering and unsettling. It could bring more fairness in some cases, and more confusion in others. The next few years will decide which way the balance tilts. This is one of the biggest structural shifts in U.S. immigration in decades, and it's just beginning. If you have a pending visa, green card, or asylum case, stay alert, stay informed, and stay prepared. The power dynamics of immigration have changed, and so has the path to justice. If you found this breakdown useful, make sure to like, subscribe, and hit the bell icon to never miss an update. This is Immiscope, your trusted source for U.S. immigration news, policy updates, and everything you need to navigate America's evolving immigration system.